Hi, I'm Don Smith from Riley Bennett Egloff in Indianapolis, and we're coming to you today to talk about settlement agreements in the context of a workers' compensation case. For years, we've gone to our clients and put on training seminars, but we're finding that a lot of our clients are now working remotely, and so we wanted to bring the video to you rather than to an office. Trying this format is something new for us, so we very much are interested in your feedback. Please let us know what you think of it and whether there are other topics that you'd like us to talk about in the future. This way you can watch it at your convenience. Now the video will be available on our website and you can refer back to it at any time. This is our first attempt, so please, we are very interested in your feedback. The presentation today concerns settlement agreements in workers' compensation cases in Indiana. There are three types of settlement agreements. The first is a State Form 1043, where there's no application pending before the Indiana Workers' Compensation Board. You can settle a case using a Form 1043 if there are no other issues involved other than the permanent partial impairment rating. Even with a pending application, you can use a Form 1043, as long as there are no other issues besides the permanent partial impairment rating. But beware, such agreements can be reopened, and the file can be reopened for a change of condition or additional medical care. Now, the second type of a settlement agreement is a stipulated agreement. We use a stipulated agreement when there are other issues to be resolved besides just the permanency of the injury. You can use a stipulated agreement that will include other terms that you're using in the settlement. Again, however, this type of an agreement can be reopened if there's a change of condition or for future medical care. It does resolve more complex issues, it's more comprehensive, and you can spell things out. But it is considered the practice of law, so a licensed attorney will have to prepare such a document for you. One advantage to a stipulated agreement is that the permanent partial impairment rating can be dated back to the original date of injury, so that the statute of limitations will run more quickly because permanent partial impairment benefits will run concurrently with the period of disability. Now, the third type of a settlement agreement is a Section 15 or compromise agreement, and this is a full and final agreement. This is not to be reopened and cannot be reopened. When there's a legal dispute involved, you can use a Section 15. What is a legal dispute? A legal dispute can be such things as this is not our employee, the person may be an independent contractor, the injury did not occur by accident, there may be a need for additional medical care that's being disputed, temporary total disability benefits are at dispute, it may be a pre-existing condition, or did it arise out of the course and scope of the employment. Something to keep in mind with a Section 15 agreement is that you are closing out future medicals, so if the agreement is for a dollar volume high enough that you're going to have to be concerned about a Medicare set-aside. That's just something to keep in mind. So those are the three types of settlement agreements in Indiana. Now we prepare the settlement agreement if it's a case we are defending, and we're going to use either a stipulated agreement or a Section 15 agreement depending on the circumstances. Many of our clients, however, send us the settlement just to handle the settlement agreement. And that's fine with us. We think we can be very cost effective when we're doing that, and we probably can give you a smoother process before the Workers' Compensation Board to receive approval. What we need in those situations is that there's a variety of documents that we have to file with these types of agreements. Most of our clients just prefer to send us the entire file, and then we'll go through and take out what we need from that file. So now you know what you need to do when it's time to settle a workers' comp case. Now, something I want to remind you about, if you don't already have one, this is our manual calling Handling Indiana Workers' Compensation Claims. And if you don't have one, please call or email us, and we'll make sure you get one of those. Thanks for tuning in. We look forward to working with you, and we look forward to your feedback.